morning, everyone. Welcome to our business at breakfast this morning. Thank you all for coming out on this gorgeous Friday morning. Today's topic is one that's pretty close to my heart, one that I've wanted to have a speaker on for some time. Many of you know I lost my sister and my dad last year, pretty close together. And, a lot of this stuff came up with, living wills, medical powers of attorney. I had a call from the palliative team, which is the call you don't want, on my sister, and they're like, did you know she has a DNR? I'm like, well, I know she applied for a fishing license, but what does that have to do with her being in the hospital? Like, some people, fishing is living, but so it was very confusing, and I wish, a lot of this would have been explained to me beforehand, so hopefully, and then I had a checkup with my doctor, like, well, do you have this on file? I'm like, well, I know I filled one out about 10, 12 years ago, but I don't know where it is, Then I had an update with my insurance agent. Well, she's like, do you have a medical power of attorney, a living will? I don't know, I probably need to update that. I probably need to get something on file, yeah. So it's something we all need, we often don't think of, so. Very fortunate to have Dr. Christine Bagliente here with us this morning. She's the Assistant Vice President and Senior Litigation Counsel for West Virginia United Health System. She's a graduate of WVU College of Law and a member of the West Virginia State Bar. In both private practice and as in-house counsel, she is focused on the representation of healthcare professionals and institutions in medical professional liability cases and tried more than 35 civil cases to verdict. She's also served as a hearing examiner for the West Virginia Board of Examiners for Registered Professional Nurses. She's written and lectured extensively on issues of medical professional liability, medical ethics, documentation in medical records, and patient privacy. She lives in Morgantown with her husband, also Dr. Bagliente Rick. So, welcome. Thank you for being here. Please ask questions. She's got handouts, so thank you.
Yes, thank you very much.
We'll get you PowerPoint set up here. And
I'm actually very selfishly glad to be invited to talk about this topic, because if more people thought about these kind of things and filled out these forms and had discussions with their families about what kind of medical care we want and don't want when we can't make decisions for ourselves, it would make my life a lot easier. One thing I want you to take away from this discussion this morning, if you take away anything, the forms and the kinds of decision making that we're talking about today do not apply only to the elderly, okay? Car accidents happen, industrial accidents happen, people fall off ladders when they're cleaning out the gutters on their house. Any of us at any moment could find ourselves in a situation where either permanently or temporarily we are not able to make medical decisions for ourselves. And if we can't make those decisions for ourselves, who do we want to make those decisions? And what kind of guidance do we want to leave with that person so that they are following our wishes as closely as possible? So what we're going to talk about today is the West Virginia Healthcare Decisions Act. It was actually passed in 2000, and it combined two different pieces of legislation: the Medical Power of Attorney Act and the Healthcare Surrogacy Act. And now those two are combined, so everything is together in one piece of legislation. We're also going to talk about the Do Not Resuscitate Act. You just heard the initials DNR, not the Department of Natural Resources. Do not resuscitate when it comes to medical. So we'll talk about that. And then we'll talk about something that a lot of people are not familiar with, and it's a concept called the mature minor rule. So most of us think if you're under the age of 18, you can't sign a contract, you can't make any kind of legal binding decisions, including medical decisions on your own. But in the medical world, there is some exception to that, and there can be situations where a minor is determined to be mature, and and they can at least participate in their medical decision making. So what is the rationale behind even having these acts in the law books? Why does the legislature care about this? If any of you are old enough to remember who Dr. Kildare or Dr. Marcus Welby are, you know, there was this time when whatever the physician said was kind of gospel, and whatever they recommended, people were going to follow, and they weren't going to question it. That's not what the world is like now. The foundation of medical ethics really is that patients have autonomy. Adult patients have autonomy. They can make decisions about their medical care, even if those decisions are contrary to what a physician might suggest. So if I get to the point, for example, in my course of treatment for a particular disease, and the physician says, well, we can try X, Y, and Z, and these things are available, but I say, no, I'm content with the way my life has been. I want to go live at the beach for the next 6 months, and I don't want to be bothered with doctor's appointments and medicine and a lot of side effects. I have the right to make that decision. And even though my physician might make a different decision for himself or for herself, even though my family might wish I would make a different decision, as long as I have decision-making capacity, I can make that decision for myself. So the legislature and the courts recognize that patients have a right to determine their own care. Also, if we have some of these forms and if we've made some of these decisions beforehand, it reduces the need for the court to get involved. So we don't have sister and brother fussing with each other and fighting with each other while dad is in the hospital, and they're going to court to try to figure out who gets to make the decision or what is the right decision for dad. And then it encourages us to think about these things ahead of time and to get our thoughts and wishes down on paper so that everybody has a roadmap when something happens and we're not able to make decisions for ourselves. We're going to talk about living wills and medical power of attorneys. They're actually two different things. And when we discuss some of the forms here in a little bit, they can be two separate documents, but they can also be a combined document. So a living will and a medical power of attorney document, if you present them to your hospital, if you present them to your physician, they're going to be presumed to be valid. You don't have to go into court and have a judge say, yes, this is valid or not. The presumption is they're valid. If somebody challenges it, like, you know, let's say a daughter challenges something I've done, then the burden is on her to convince the court that it's not valid. But until that determination is made, my doctors and the hospital are going to be able to rely on the document that I provide to them. They're presumed to have been executed when you did have made decision-making capacity. So unless somebody can prove that I was already in the throes of Alzheimer's disease as of a certain date when I signed this document, the presumption is I was of sound mind when I signed the document. There are certain legal requirements in the statute about what has to be included, like there have to be 2 witnesses on the document, it has to be notarized. But as long as the document is in a substantially similar form to what the law requires, it will be honored. So for example, let's say that you used to live in Indiana and you filled out your medical power of attorney document there, and you end up in West Virginia. Let's say the Indiana medical power of attorney only has to have 1 witness signature, but ours in West Virginia is supposed to have 2 witness signature. We're still going to honor that because it sets out what your wishes are and it gives direction to your healthcare providers. And so they are not going to stand on ceremony and say, well, this is invalid because it was done in Indiana. And all states do that. They will honor each other's medical power of attorney and living will documents, even though they may not be exactly in the form that that state requires. They apply living wills, medical power of attorney, and healthcare surrogates, which we'll talk about too. They apply to adults who are 18 or over, to an emancipated minor. An emancipated minor and a mature minor are two different things. In West Virginia, there's only two ways to be an emancipated minor. You have to be under the age of 18 and married, or under the age of 18 and declared by a court to be emancipated. Now this is where it gets tricky. What if you're a 16-year-old and you've had a baby? That doesn't make you emancipated. If you're a 16-year-old and you're married and you've had a baby, that makes you emancipated. But unless the court declares you to be emancipated, just having a baby under the age of 18 doesn't make you emancipated, which makes no sense legally, but that's what the law says. DNR, do not resuscitate, and post forms. A post form is a physician order for scope of treatment. We'll talk about that in a little bit too. They apply to adults, emancipated minors, and mature minors who are at least 16 years old. So what is a living will? A living will is a document that says what you want to have done if you don't have the capacity to make your own decisions. And it can be as broad or as detailed as you decide to make it. So, for example, I wrote in my living will, and I've told my children and I've told my husband, my independence and my dignity are very important to me. So even if I'm not giving them specific instructions about a particular procedure or where they're gonna send me when I need to come home from the hospital and I can't come back to my living situation, they know one of the guiding principles for their decision-making on my behalf are respecting my independence and respecting my dignity. Now, I could also get very specific and say, if I get to this certain point, I don't want to be intubated. If I get to this certain point, I'm okay with not taking any more antibiotics. If I get to this certain point, my preference would be to die at home with hospice if that's possible. I can get very specific, or I can keep things broad. And that's something that you should discuss with family members and think about yourself if you have these documents, is that as you progress perhaps in a disease process, or as you get older, your thoughts about your medical care may change. So you may have said all along, you know, I want everything done. I want, you know, full court press no matter what. But then you may get to a point in your care where you say, you know what, I've already been through 2 courses of chemotherapy. I don't want another course of chemotherapy. I'll still do CPR, I'll still do this and that, but I don't want another course of chemotherapy. So these documents can be changed and updated. They are not something set hard and fast in concrete once you've done it. But it is important, if you did one, you know, when you were in your 20s, to look at it again when you're 30s, 40s, and especially look at it again if you find yourself with a chronic medical condition or you know, some other medical problem that maybe changes your thoughts from what they were initially. They give express directives, and going back to what I said about patients having decision-making capacity and medical ethics, the physicians who are taking care of you want to know what your express directives are. They want to know what your values are. They want to know what you would say for yourself if you were able to do so. And they want to be able to respect that. But if they don't have a living will, if they haven't discussed that with you before, they're kind of in the dark. And so it makes it harder for them to communicate with your family and create a treatment plan with your family that respects your wishes if they don't know what your wishes are. A medical power of attorney is who you want to make decisions for you, if you can't make decisions for yourself. If you have a living will and you've set out, I do want this or I don't want that, your medical power of attorney is bound by those directives. So, for example, if I say, when I pass, I would like for my organs to be donated, my medical power of attorney can't come in and override that decision. I have made that decision in advance. My medical power of attorney has to honor that decision, even if, in their mind, maybe I shouldn't, or they wouldn't want me to donate more organs. Now, if my living will doesn't say anything about donating organs, and I don't have anything on my driver's license about donating organs, then my medical power of attorney can make that decision for me. But if I have already said in a document what I want, they are supposed to follow my wishes. You can create your medical power of attorney document so that it designates more than one person. So what I've done with my medical power of attorney is I have my husband, and then if my husband can't or doesn't want to serve in that capacity, I have my older daughter. And you can do that as well. You can also change. Let's say that I've designated my husband, but then he gets sick himself and I don't want him to have the stress or the pressure. I can change my medical power of attorney and living will documents to make it my older daughter and then make my younger daughter the backup person. So again, it's not set in stone just because you create the document in a certain way the first time. It can be modified. Whoops. So any of the documents that we talk about today are really only triggered, they only become operative if you lose decision-making capacity. So a lot of times what we find, especially with elderly people, is, daughter brings mom to all of her doctor's appointments. And mom says, well, she's my medical power of attorney, just let her make the decision. Well, that's not how it works. If mom still has the ability to make decisions, mom has to make the decisions. Now, she can consult with her daughter, of course, and she can follow her daughter's advice or not follow her daughter's advice. But the daughter doesn't get to make the decisions as long as mom is able to make the decisions. The daughter doesn't get to sign the consent for surgery form unless mom has lost her decision-making capacity. The daughter doesn't get to make the decision about whether mom goes home with hospice or goes to a nursing home if mom can make the decision. Mom still has to participate in those decisions. So until mom loses her ability to make decisions, the medical power of attorney is just kind of standing in the wings, waiting to be triggered or waiting to be appointed to make the decisions. But those decision-making authority doesn't come until mom loses her decision-making capacity. The same thing with a medical power of attorney or a healthcare surrogate. There are circumstances, chronic mental health problems are one of them, where a person can have periods when they do have decision-making capacity and have other periods when they don't have decision-making capacity. So a medical power of attorney might kind of come in and out of the picture. So if I have a chronic mental illness and I'm in a period where it's really flared up and I can't make decisions for myself, then that medical power of attorney can step in and make decisions for me during that crisis. But then once, I'm medicated or my symptoms calm back down and I'm able to make decisions for myself, then the medical power of attorney again kind of steps in the background and I make my own decisions at that point. Incapacity, whether you can make decisions or not make decisions, is a medical determination. So, you know, my daughter might say, oh gosh, mom's been off her meds. She's really having a hard time. I can't deal with her. She won't listen to anything I say. She's not eating right. I think she's not able to make decisions for herself. Well, the doctor might take what my daughter says into consideration, but the doctor herself has to do an examination and actually make a determination whether I have decision-making capacity or not. And they write a note in my medical record that says I don't have decision-making capacity. They give the reasons that they think I don't have decision-making capacity. And if they're able to tell at that point, they say whether they think this is a permanent condition or whether it might be a temporary condition. And then from that point forward, you know, June 2nd at 8:45 a.m., you know, at that point, I have lost my decision-making capacity, and my medical power of attorney can step in and make decisions for me. Just because someone is of advanced age, just because someone has a disability, just because someone has a mental illness, or just because someone has an intellectual disability, doesn't mean that they don't have decision-making capacity. So even if I had a person who had an intellectual disability, if they're able to understand what their medical condition is, if they're able to understand the treatment that is being proposed, if they're able to understand the benefits and the risks of the treatment, and if they're able to clearly express their wishes about what they want or they don't want, then their decision should be honored, should be followed. Again, though, if you have someone who has an intellectual disability and they really can't understand like what a side effect is, or if they really can't understand what your after surgery care would be like, then you would probably have to have someone involved to make decisions for them. And again, that's a very kind of delicate decision making that has to be done with the physician's input to determine whether the person does have decision making capacity or not. The attending physician, a qualified psychologist, a physician assistant, or advanced nurse practitioner can make the decision about whether someone has decision-making capacity. They put it in the medical record, as I said. And then if I am the patient and they're saying, I don't have decision-making capacity, they're supposed to tell me that. Although if I don't have decision-making capacity, I don't know whether I would understand that, but they're supposed to inform me of that. Before you can determine that somebody who has mental illness or an intellectual disability does not have decision-making capacity, there's supposed to be a second opinion. So it's not just like one physician who can say, oh, you have schizophrenia, so you don't have decision-making capacity. There would need to be a second opinion to say, yes, for this period of time, this person who's suffering from schizophrenia doesn't have decision-making capacity. Same thing with an intellectual disability. But if you're actually treating someone for mental illness, then you don't need that second opinion. I haven't explained what HCS is healthcare surrogate. I haven't explained what that is in detail. But if I have not executed a medical power of attorney, I haven't pre-designated who I want to make decisions for me, then that places the physician in the hospital in the position of having to determine who's gonna make decisions for you. And we'll see a slide in a minute. The legislature has given us kind of a list of priorities that you start with. And the physician in the hospital go through that, and they would start, for example, with my spouse. Is my spouse able to make decisions for me? Are they willing to make decisions for me? If the answer to both of those questions is no, then they would go to one of my adult children. If the answer to both of those questions with all my adult children is no, then they would go down the list. And they try to find a person who can act on my behalf and make decisions for me. And the hope is that that person somehow would know what my wishes are, or if they don't know what my wishes are, would at least act in my best interest. But you can see how having the medical power of attorney is much more preferred, because I've said this is who I want making decisions for me, and hopefully I've had a discussion with that person about what my wishes would be. Whereas with a healthcare surrogate, you're not sure whether that person would have ever had a discussion with me about what I would want. And you're just kind of hoping against hope that, you know, the priority that the legislature has set out for us is gonna find the person who really has my best interests at heart. I will tell you, it's a sad fact of medicine nowadays that more and more we find people who are taken advantage of financially by family members, and it's a very sad situation when you feel like we've appointed this person as the healthcare surrogate to make decisions for this person who can't make decisions for themselves, but we really have this very icky feeling that they're maybe not making decisions in the best interest of the patient, but they're making decisions that will make sure the Medicare checks keep coming. And it happens. And that's another reason why it's so important, if you can, to have these things done ahead of time.